Assalamualaikum warahmatullahi wabarakatuh. My name is Nurin Farisa binti Abdul and my matric number is 1200689. I'm from group KMB1. So today I would like to present the individual presentation of case review, which is Dezon Electrical Engineering Sudirman Berhad versus Chin Po Yi and Anar. So, let's start the presentation with summary of facts and issues. About the facts, the case involved between the Dezon Electrical Engineering Sudirman Berhad as the plaintiff against Chin Po Yi, which is sole proprietor of AAFT, as the first defendants, and Tan Liang Kui, which is the first defendant's husband, as the second defendant. The case was filed by the plaintiff to claim the sum of project of the plaintiff against the first and second defendants. On 20 December 2018, the plaintiff had sent a letter of award to AAFT. In the letter, it states that AAFT is subcontractor to do mechanical and electrical works in the project. Also, it states the commencement date and completion date. And the second defendant had signed the letter, and he also signed a guarantee and indemnity. But AAFT did not complete the work due to their workers went on a strike because AAFT did not pay their wages, and it caused a delay for the project. And then AAFT also was not financially able to complete the work, and they have the financial problems. Therefore, the plaintiff had purchased construction material for AAFT to use in the project, but AAFT workers did not comply with site rules, and the plaintiff was penalized. After that, the plaintiff sent a letter to AAFT with 3 documents, and if AAFT did not respond within 15 days, the plaintiff will consider that AAFT had accepted and agreed. Because of the letter, Ms. Laviania Padmanathan and Co., which is the representative of the second defendant, sent the letter with mark without prejudice to the plaintiff, and it stated in the letter that it denied with the 3 documents, and also state the AAFT had completed the work at least 40%. On 26 February 2020, the plaintiff solicitors sent a letter to Ms. LPC to deny the allegations that contained in the letter that Ms. LPC had been sent before this. Next, it is about the issues arise in the case. So, the first issue is whether the Ms. LPC letter can be as evident when the letter had been marked without prejudice when it's sent to the plaintiff. The second issue is about whether the defendants can rely on Order 14(1) Clause 2B of the Rules of Court 2012 to resist the appeal that the defendants' allegations have been raised against plaintiff. The third issue is about whether the defendants can rely on the 2 following grounds to oppose this appeal, which is the second defendant's claims that he did not understand all documents in English, but he had signed it, and the defendant's allegation which is fraud. And the last issue is whether the doctrine of equitable estoppel apply against the defendants in this appeal. We continue the presentation with the next part, which is decision. For this case, the decision from senior counsel is set aside. The judge has made the final judgment for the claim sum of plaintiff, which is entered in favor of the plaintiff against the first and second defendants. Not only that, the defendants also shall pay interest rate at 5% per annum on the plaintiff claim sum, and it must be paid until the full settlement of the claim sum. The defendants also have to pay costs to the plaintiff with the same interest rate, which is 5% per annum on the costs until the full payments. Last but not least, the defendants also shall pay the cost of this appeal to the plaintiff with the same interest rate, which is 5% per annum. Now, we at the last part of presentation, which is legal application in the case. The first application is Section 10 Clause 1 of the Contract Act 1950, which is what agreements are contract. In this section, it states that all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and not hereby expressly declared to be void. While the second application is Section 14 Clause A and Clause E of the Contract Act 1950, which is free consent. Consent is said to be free when it is not caused by coercion or mistake. The third application is Section 17 Clause A and Clause E of Contract Act 1950, which is about fraud. Fraud includes any of the following acts committed by a party to a contract or by its agent or to induce him to enter into the contract. The Section 17 Clause A is the suggestion as to a fact of that which is not true by one who does not believe it to be true, while 17 Clause E is any such act or omission as the law especially declares to be fraudulent. The next application is Section 18 Clause A and Clause C of Contract Act 1950, which is a misrepresentation. Misrepresentation includes the positive assertion in a manner not warranted by the information of the person making it, of that which is not true, though he believe it to be true. Also include causing, however innocently, a party to an agreement to make a mistake as to the substance of the thing which is the subject of the agreement. The next application is Section 115 of the Evidence Act 1950. This section is about Estoppel, which is when one person has, by his declaration, act or omission, intentionally caused or permitted another person to believe a thing to be true and to act upon such belief otherwise than but for that belief he would have acted, neither he nor his representative in interest shall be allowed in any suit or proceeding between himself and that person or his representative in interest to deny the truth of that thing. And the last application is Order 14 1 Clause 1, 2 Clause 1b, and 3 Clause 1 of the Rules of Court 2012. For Order 14 1 Clause 1 is about the application by plaintiff for summary judgment, while Order 14 2 Clause 1b is the manner in which application under Rule 1 shall be made. And the last is Order 14 3 Clause 1 is about the judgment for plaintiff. I think that's all from me. Thank you.